Welcome to Easy Learning. In our considered opinion, the Settlement Commission could not have returned these findings, which could only have emerged from a formal adjudicatory process. The findings of the Settlement Commission amount to ignoring the statements of suppliers of raw material, the evidence of the buyers of the finished goods, admissions of various personnel of respondents, including their directors, as well as the computer printouts. The submission of respondents number 1 and 2 endorsed by the departmental representative who appeared before the Settlement Commission that the only evidence of clandestine removal without invoices of excisable goods was contained in the computer printouts is, on the face of it, incorrect. A bare reading of the show cause notice reveals that, apart from computer printouts, the allegation that respondents number 1 and 2 were clearing the finished goods unaccompanied by invoices was supported by the statements of witnesses. Evidence of receipt of unaccounted raw material in the form of the statements of the material suppliers, the recovery of unaccounted cash from the premises, shortage of finished goods in the premises of respondent number 1, vis-a-vis the record and balance in the register, and seizure of unaccounted finished goods from the godown of respondents number 1 and 2, whereunder such removals were allegedly effected. The impugned final order of the Settlement Commission completely ignores this evidence. Regarding the computer printouts, the Settlement Commission has also failed to note the fact that the figures in the computer printout had been compared with other records and had been found to tally. The Settlement Commission could not have held that the revenue had failed to adduce evidence, particularly in the context of production capacity of respondents number 1 and 2, as the occasion to produce any such evidence would have arisen only during adjudication proceedings. We are also unaware of any law which entitles respondents number 1 and 2 to compute demand for the period not covered by the diaries on a pro rata basis. The removal of excisable goods does not take place on pro rata basis, but in actual fact and duty on such removals has also therefore to be paid on actual and not on pro rata basis. The error in the perception of the Settlement Commission regarding its jurisdiction is perhaps most starkly underscored by the findings returned by it in the impugned final order with respect to the production capacity of the units of respondents number 1 and 2, which never constituted a part of the show cause notice dated 16th January 2013 and was cited by respondents number 1 and 2 in their defense. The onus to establish that during the period of dispute their production capacity was insufficient to maintain the allegation of clandestine removal and under invoicing, as contained in the show cause notice, lay therefore squarely on respondents number 1 and 2. As no adjudication took place, neither did respondents number 1 and 2 discharge this onus, nor did any occasion arise for the revenue to lead any evidence or in any other manner seek to disprove the same. Full stop.